Good morning.
Good morning.
Nice to see so much interest in something we do from time to time. Welcome all of you. My name is Anthony Roisman. This is a special hearing in case number 19-1081-PUT, petition of Noverco Inc. for approval of indirect acquisition of a controlling interest in Vermont Gas Systems Inc., Green Mountain Power Corp., and subsidiaries of Green Mountain Power Corp. I am Anthony Z. Roisman. I am the chair of the Vermont Public Utility Commission. With me today on my left is Commissioner Sarah Hoffman, and on my right, Commissioner Margaret Cheney, and some of our staff who've been working on this matter. What we intend to do today is to take 2 hours to hear a request to stay an order which we issued last week approving the proposed acquisition of the indirect controlling interest. The first hour will be devoted to evidence. If any party has evidence that it wishes to present by witness, document, or otherwise, we will entertain that. And if that takes less than an hour, we will then move to the oral argument phase of the case. We'll set aside an hour for oral argument. Because we're not aware yet of the position of the department, we can't yet determine how to divide that time, but the goal would be that all parties who are on one side would get half of the time, and all the parties on the other side would get half of the time, and we'll devote 1 hour to that oral argument. Does anybody have anything preliminary in the way of process that we should be addressing before we get started?
I have a question with respect to the process. The notice of the hearing that was issued yesterday had a number of questions from the commission directed to Noverco. Is your expectation that those would be addressed in the initial hour that you have devoted to evidence?
Yes, to the extent that it is an evidentiary answer. If we ask you a legal question and you want to answer it as an attorney during the oral argument, that would be fine. All right? So we'll start with you.
Before we get started, Mr. Chairman, I just
Yes.
want to let you know, Mr. Porter's here today, but he has a separate commitment in one of your other hearings this morning, so we're going to lose him. I think at 9:30.
Okay, yes, and I'm sorry. I should take appearances from the parties. We'll start with the department.
I'm Dan Burke on behalf of the Department of Public Service. With me is the Director for Public Advocacy, James Porter. As I said, Mr. Porter will be here for about a half hour.
Okay, and for the intervener.
James Dumont here for interveners, many of whom are with us today.
I'm Deborah Bufard from Sheehy, Furlong, and Beam. I'm here on behalf of Noverco Incorporated today. Joining me is my law partner, Owen McLean, and from Noverco, the president and board member, Renaud Fauché. And as well, given the commission's questions with respect to the plan of arrangement and the closing, Noverco has requested that the attorneys that have been involved in negotiating the transaction, preparing those documents, join us today. So at the end of the table here is Attorney Patrick Boucher from McCarthy Petro, and as well is Attorney Sonia Struthers.
Welcome. We're delighted to have our Canadian colleagues join us. Thank you.
We're delighted to be here. Yeah, it's such a beautiful day.
Thank you. All right, Mr. Dumont, do you have any evidence that you intend to present today?
Well, I too have lots of questions for our colleagues from north of the border.
Perhaps, Mr. Dumont, you are soft-spoken. Perhaps we can get you to use a microphone. Have you ever been called soft-spoken before?
Can you hear me?
I can hear you, but I don't think this
Since
is.
the light is on, the green light is on,
There, I think it just.
can you hear me now?
I could hear you before.
There you go, Mr. Porter.
Hello, hello.
Yeah.
There you go.
Yeah, okay. Yes, I do have questions for our visitors from north of the border. And in respond to the Commission's order, Mr. Gardner is here, who can discuss the irreparable harm that the interveners would suffer. However, I think that is essentially a legal question because the facts are undisputed that the interveners' post-judgment motions and our appeal will be mooted without a stay. And given those facts, under the case law we submitted, there will be irreparable harm.
I'm sorry, Mr. Dumont, you're making a legal argument, and you'll have your opportunity to do that. I still have the same question for you. Do you have any evidence that you want to introduce?
Yes, Mr. Gardner?
Let me ask you then, I assume that that's what you were going to do. As you know, the normal rule is that attorneys are not witnesses when they appear in cases. And so let me ask Ms. Buffard, what is your position on whether or not either of the attorneys who are here from Canada may be called as witnesses to be examined by Mr. Dumont? Is that an issue, or do you have no problem?
The witnesses, the attorneys that we have here today are here to, they have worked on the transaction that we have requested the commission approve. The interveners have their burden of proof with respect to their motion, and the witnesses that Noverco has here today have not been called by the interveners for purposes of that motion. These individuals are here to address the commission's questions. So we would oppose them being called if the plan from Mr. Dumont is that they be called in connection with the motion to stay. There are other vehicles for him to do that.
Mr. Dumont, I think the scope of your examination of the witnesses, and it does appear that there'll be witnesses, will be defined by the scope of their direct. So until and unless they've given direct, I don't think it will be appropriate for you to do cross. What I wasn't clear about, and now I think Ms. Buffard has made clear, is that they will testify. They'll come up and I assume either she or Mr. McLean will ask them some questions, they'll give some answers, and you will have an opportunity to then examine them after they have given direct testimony.
If I may, I think the commission is confusing two related issues. One is whether attorney-client privilege is being waived. If they testify, it will be waived. There's no doubt about that. They appear not to be here in the function or office of attorneys, since they have not filed a motion to appear pro hac vici. They're here as witnesses. So if they testify, the privilege will be waived. That's a different issue than the scope of cross-examination. In other jurisdictions, but not in Vermont, the scope of cross is limited by the scope of direct. In Vermont, the rule is to the contrary. If a witness is offered and gives direct testimony, the scope of cross is not limited by the scope of direct.
We'll deal with that when we see what questions you have to ask. As to the question of whether or not the attorney-client privilege is waived, we'll also deal with that if and when it comes up. Explanations that the attorney is capable of testifying in some matters and not waiving all the attorney-client privilege. But We don't have to cross these bridges until we get to them.
Yes, that's always a wise legal decision.
So, if I understand correctly, you have no direct testimony.
No, he said he had Mr. Gardner.
Mr. Gardner would be sure to
Okay.
testify.
All right.
Mr. Gardner, can you take the stand?
Mm.
Is this working? Yep.
Good morning, Mr. Gardner.
Good morning.
Do you swear or affirm under penalty of perjury that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Please state your name.
My name is Jeffrey Gardner.
What has your role been in these proceedings?
I am an intervener, one of the 19 interveners in this case.
What has your role been within the group of interveners?
I think it would be fair to say that I've been the lead intervener insofar as I've been the contact with you, or the contact between you and the group as a whole.
Could you describe the harm that the interveners will suffer if a stay is not granted?
I think there are several things. The first is that if the commission were to reject our motion for stay, I think that would have the effect of making an appeal futile and would moot an appeal. We entered this case to oppose the buyout by Noverco of Valinor shares. And the reason we did that was that we thought that there were consequences that might follow from that deal that would adversely affect not only us, the interveners, but the public interest and the people of Vermont as a whole. And we entered with the idea that we would be able to see through to its legal end this entire process. We have a right to appeal. We have a right to have our appeal heard. If the stay goes into effect, our goal in entering this case is decided without appeal. The deal will go through without our appeal being heard. Seems to me, commonsensically, and I think also probably as a matter of law, that's out of order.
You said if the stay goes into effect, you meant to say the stay does not go into
If the stay, yes, does not go into effect. So that's one reason. And I think that is irreparable harm to our rights. Second thing is that, as everyone in this room knows, those who understand what's going on and those who are befogged by it, this is an incredibly intense and complicated matter. The structure of the corporations that eventually come to own Vermont Gas and GNP is astoundingly complex. And it has taken an enormous amount of time and effort, and I must say money, to go through this case, and here we are where it seems to us that the objection to our stay completely erases the effort we've put in without actually having the right to go again through to the end of this process. Many of the arguments, as I understand them, that the Noverco lawyers have presented actually go to our motions to either amend or vacate the commission's order. That hasn't been heard. There hasn't been a response from the commission to our motion. If this stay does not go through, then again, that's short-circuited. This time the short circuit would be of the commission's ability to rule on the motion that we've presented. So that's another thing. The third thing, I think, goes to something that really is troubling. And this struck me immediately on reading the commission's order. The first paragraph on page 12. I really want to read this whole thing. It's short, and it's troubling. This is the third from the last paragraph. The commission says, although we have decided to approve the proposed transaction, we remain concerned by the lack of reliable and firm evidence in this record from Noverco on critical matters related to potential impacts, both positive and negative, of the proposed transaction. This lack is directly traceable to the absence of Enbridge and the CAS from this proceeding. Matters of concern to us and to the interveners, so there's a convergence here of our interests and your interests, have been left to some conjecture, because of the inability to hear directly from and to have access to documents in the possession of Enbridge and the CAS, which are significant parties in interest because they are the ultimate parents of, and thus exert or exercise direct and indirect control over the various entities and eventually own Vermont Gas and GMP. To a good degree, our concern in this case has been to see exactly what the level of control of Enbridge, particularly. I think CAS really is a financial partner. The body that makes the decisions about infrastructure for fossil fuels is Enbridge. And our goal has been to see what the role of Enbridge has been, is now, and is likely to be in the future. And that, as you acknowledge here, we don't have enough evidence. We don't have credible and reliable evidence that answers the question that you say here seems to be critical, and that is, where is the line between direct and indirect control of the Vermont utilities, GMP and VGS, by Enbridge? And it seems to me, too, that without that level of evidence, we are left, you are left, and have decided on the basis of conjecture rather than the basis of evidence that this sale should go through. And it does seem to me both that that is an appealable issue, and it also is one, if it is not appealed, will harm our interests because it goes directly to not only our interests and what we were seeking to accomplish by entering this case, but it also goes to your interest in the case and your concerns as well. For that to be short-circuited by allowing, or by not allowing the stay to go through, I think is not only harm to us, but it's irreparable. The sale will go through, that will never be heard. I also think it's a terrible precedent for any other case of a similar kind that comes back to this commission. And there's another thing that, as I sit here, occurs to me. And that is, we also, it seems to me, we being not just the interveners, but we being virtually everyone in this room, Canadians accepted, we as Vermont citizens have a right to the confidence that the regulatory commission that hears these issues and makes decisions on them acts in a way that we can rely on to be credible, to exercise fairness, and to be susceptible to scrutiny. An appeal to the Supreme Court is not only a measure of the issues in the case, but it's a measure of how well the commission has performed. I think what I just read is an indication that there's a question about that. I think you no less than we would like to have that resolved by the state Supreme Court. Without that being heard, I think also part of the irreparable harm is that our confidence in your credibility as commissioners is not reliable, just as some of the evidence in this case is not reliable.
Thank you.
Anything more? Ms. Buffard, you have any questions?
Could I just have 30 seconds here?
Sure.
To take a look at my notes. Just have a couple
Sure.
follow-ups. You had talked initially about concerns with the futility of an appeal, mooting an appeal. Can you explain to me a little bit of your legal background to give those opinions?
I have no legal background, no formal legal background. I know how to read.
And
I know how to read carefully, if I may say. And let me explain what I meant by that. And that is, what we wanted to achieve in this case was to prevent a sale. That's clear. If the sale goes forward tomorrow, while we still have a right to appeal, then our ability to make that case to the state Supreme Court is short-circuited. At the same time, I think if the commission grants your motion to reject our request for a stay, then they in fact have done the same thing. They've said, we cannot hear this through to the end, because they may decide that our motion to amend is great, and they may decide that our motion to vacate their order is terrific. And so they vacate or they amend, but the deed is done because you accomplished the sale by preventing the stay. Does that make sense? Do I need a legal background for that?
I understand the answer to the question, thank you. One other point you were talking about was with respect to decision-making between Cass and Enbridge. You don't have any personal knowledge, do you, with respect to how decision-making takes place, correct?
Yes, I do have personal knowledge. The personal knowledge I have is all based on Mr. Fouchot's testimony. And actually,
Do you have any first-hand personal knowledge of how decision-making at the Cass or Enbridge is made?
no, and as a matter of fact, I'll have even less of that if this sale goes through, because what will happen if the sale goes through is the public shareholders will be cut out. There'll be no annual meetings, no annual reports, no public reporting, aside from any that occurs as a result of public debt, and that's quite limited. So we'll know less rather than more, and I think that's true of the commission too.
Do you have personal knowledge of the harm that will ensue to Noverco if the stay is granted?
I read your filing, and I see that you claim that Noverco will lose 100,000 Canadian dollars a day, which I think is about 73,000 American dollars at this point. To my mind, that's trivial. This is a $1.2 billion sale. I think over a period of 30 days, that would amount to what, about 2%, maybe a little more.
Those are the questions I had for the witness.
Mr. Burke?
I don't have any questions.
Mr. Dumont, do you have any to redirect?
I do not.
Thank you very much.
Thank you.
Mr. Dumont, do you have any additional evidence you wish to offer?
No.
Ms. Bouffard?
Are you asking if I have evidence with respect to the motion to stay or with respect to the questions that the commission has posed?
The questions we ask are pertinent to the motion to stay, so the answer to both questions is yes.
Would you like us to proceed then with addressing the questions from the commission?
Yes, of course.
I've asked, I know for one brief moment here, but I am concerned and want to make sure that my client is comfortable with proceeding in light of the clear plan from Mr. Dumont that he has articulated that if witnesses testify on behalf of Noverco that are attorneys, the privilege is waived. So before we get started with having them testify, I want to take an opportunity to speak with my client about that before we proceed, so if I could just have a few minutes, I would appreciate that.
Can I ask one clarifying question?
Sure.
Mr. O'Shea is not a lawyer, is that correct?
That's correct, he is not. Thank you.
Okay, we'll recess for, is 5 minutes
That's
sufficient?
plenty, thank you.
For the Commission's benefit, in case you weren't aware, it's Vermont Rule of Evidence 510A.
We got a lot of room here, huh?
So under the law, they can give a case of parties and then the evidence is given to the commission. Yeah, in this case, and that's part of the Vermont Administrative Procedures Act, so all agencies. Because once the briefs were filed, they made a determination to take the evidence for record on.
Barbara, you prepared to proceed?
Yes, I am, thank you. So, given the concern that has been raised with regard to waiver of the privilege, let me start by saying we have requested the attorneys from McCarthy-Tétrault to talk with the commission about the plan of arrangement and the contract negotiations, because they are the most familiar with the deal and the documents, and in that regard are the most knowledgeable witness. But we are very concerned about having them testify here today and then being presented with an argument that privilege as to the entire negotiation has been waived. So we would request an order before we start with these witnesses that they are here to address the commission's questions only, and that in doing so, they are not waiving privilege.
I think the question, Mr. Bouffard, is what they're going to testify to. They clearly cannot be precluded from being cross-examined on what they talk about, and matters that are related to that. The rule in question says that the particular matters, well, I'll read it. The person upon whom these rules confer a privilege against disclosure waives the privilege of that person or that person's predecessor, while holder of the privilege voluntarily discloses or consents to disclosure of any significant part of the privileged matter. So it's the scope of what they say that determines the scope of what they waive. You can't rule in advance other than to say that they're not going to waive anything that's not within the scope of what they testify about. But there's obviously room for argument as to what's within that scope. And until we see the specifics and hear what Mr. Dumont wants to ask, it's very difficult for us to, in the abstract, give a ruling that would give you the confidence that you seem to seek in advance.
What I'm concerned about is not necessarily what questions are presented on cross-examination today. We can obviously deal with those today. What I'm concerned about is that an argument that if we open the door today, that there will be no option to claim privilege going forward, and that we will be requested to provide at some point in time documents outside of this proceeding today, or communications with respect to the transaction. So I'm concerned about if we start down and take a few steps today, that will be perceived and deemed opening the door entirely. That's my concern.
I don't see any way that we can close that door for you. Let's say a court in Canada gets some complaint filed about these companies, and they point to this proceeding. Even if we said you don't waive your privilege by testifying here, that court will have to decide under the rules that it uses. The same for the Superior Court here, the same for the Agency of Natural Resources or the Environmental Board if they were holding hearings. So I don't think we can give you that confidence. I think you have to decide, can you offer the information you want to offer without having those attorneys testify? If they do testify, you run some risks. We cannot make those risks go away.
Can I also ask Mr. Fauché, our questions? We wrote up some of our questions, and obviously there are questions that arise from his affidavit. Is he able to answer at least the questions that pertain to his affidavit?
Yes, he's available to answer those questions, and what we thought would be an efficient way to proceed, since there are parts of those questions that are legal and related to the documents, and then some that are really about the harm to Noverco, those that we would ask to have a panel, and that the witnesses could present their responses that way, and we thought that would be the most efficient way to proceed. But Mr. Fauché is here as well to address questions about his affidavit.
Maybe it'll help you to make clear what our concern is. In the letter that was sent to us before you made an official filing in the case, you made the statement that this transaction would be irreversible. The interveners have claimed that if the transaction's irreversible, then if they don't stop it now, everything after this becomes irrelevant. Our motion to reconsider, appeal to the Supreme Court, if it's truly irreversible. So the question and our concern is that statement accurate? If the court, if the Supreme Court, or if this commission were to decide at a subsequent date that this transaction should not have been approved, is this capable of being undone? Yes or no? Now, is that Mr. Fauché who answers that? Is that you on behalf of your client who answers that? Is it the attorneys from Canada who answer that? That's really the crux of that part of this state proceeding. Is that the question that your witnesses are prepared to answer?
Yes, if I could. There are multiple components, I think, to that question. One is what we meant in the letter by irreversible, meaning press the button and you unpress it. And Mr. Fauché and the other witnesses can also testify to that. As to the question of whether or not we can put these witnesses up on the stand and give the commission the opportunity to, I think, learn about some of the substantive bases and complex components of the transaction that are driving some of the strict provisions of the contract with Ballinaire. I think could I see if this works? I think we don't need a preliminary ruling on a specific piece of testimony, but if we could get a ruling that merely taking the stand and testifying about one thing is not a broad, universal waiver of the privilege, then I think that we could get to the point where our witnesses would be comfortable evaluating the extent to which their testimonies would become a waiver. But in the absence of in the face of a legal contention that merely taking the stand on any issue is a universal waiver, I think we'd like a ruling that that is an erroneous view of the scope of the waiver. So if we could do that, I think then we could get productive and get these folks up on the stand. Does that make sense?
What does the department have to say about this?
And I think I'd want to do some research before I really want to agree with that position.
I'm sorry,
Mr.
we can't hear you.
Mr. Burke, you do have to use the microphone.
At this point, I don't think we would be able to agree with the commission's order that limit the scope of the privilege at this point. I would want to do some legal research into that, but no, I don't think we would agree with Mr. Norman at this point.
Mr. Dumont, can you give us, are you prepared to give us some idea of just how far you think you want to go with these witnesses, either to give them some comfort or to help them understand why they are treading in very dangerous water?
I don't want to give them any comfort, but I will answer your question. The rule answers your question. Rule 501B1 states that the waiver extends to an undisclosed communication, in other words, what they haven't volunteered or what hasn't come out on direct, only if A, the waiver is intentional, so it's not, they said something by mistake, or they were speaking to their client and it was overheard. The waiver is intentional. B, the disclosed and undisclosed communications or information concern the same subject matter. And C, they ought in fairness to be considered together. That answers the question.
They're going to testify about why they believe that the transaction needs to proceed on the schedule that the Noverco arrangement agreement has, and why they can't move that date. In effect, that's what a stay would do, move the date for that transaction. That's the scope of what they're going to testify to. Is it your intention that you're going to ask them questions related to why did you enter into this deal? Did you enter into this arrangement because you wanted to cut the public out of any participation in the management and control of GMP and VGS? In other words, how wide is your intent to go?
I'd like to answer that in two parts. First, I have not heard an answer to the chairman's question just a few minutes ago, which is the crux of the matter is the decision irreversible, or will the closing be irreversible? If the witnesses tell you, yes, the closing will be irreversible, then we could do that in about 3 minutes, and you will have the answer to your question, and I'm not sure why there would be cross-examination on that point, because they've now proven that the stay must be granted. So it's hard for me to figure out where my cross is going to go. We have the letter submitted under the rules governing lawyers that told you this will be an irreversible commitment. Do we have Mr. Fauché here and two eminent counsel to say that Mr. McLean was wrong? Where's this going?
Look, Mr. Dumont, I don't want to dampen your enthusiasm, but I'm not prepared to tell you that if the commission concluded that the transaction were irreversible, that would automatically mean the stay would be granted.
So
Because there is another piece to that, which is irreparable harm proven by the proponent of the stay, and we have serious questions about that. So don't assume that if they answer the question, yeah, it's irreversible, that's the end of the discussion.
And I don't assume that, thank you. However, the the second part of my answer is that, which is sort of where you're going, that the same subject matter, how do we define that? Which is 501(b)(1)(b). What is the same subject matter? The subject matter is whether the grounds for a stay have been satisfied. So if the witness is here to say, to address that, then I should be able to cross-examine them not only about, is this irreversible, but also what's the harm to their client? Is it a harm that is being caused by the stay, or is it a harm that they've inflicted upon themselves by rushing the closing process in the attempt to moot this proceeding? Those all directly relate to whether a stay should be granted. If they're going to testify about whether a stay should or should not be granted, in fairness, under the rules, I should be able to examine them about not just the one criterion, but all four.
Ms.
I need
Bouffard,
to,
if that were the scope of Mr. Dumont's examination, would you find that objectionable to have the attorneys answering those questions?
well, I think before, I don't have the comfort, I guess I need to proceed with having opened the door to a global waiver of the privilege. And so I think that these questions that the commission has asked us to come and address have legal components, they have fact components to them, and you have the plan of arrangement. And what that says is, those are legal issues, and we can talk about those. Don't know that I need a witness. I certainly think it would be helpful to hear from the witnesses. But before we get there, I have to clarify a few things here that we've heard from Mr. Dumont. First of all, there wasn't any error in the letter that we sent in. When we were talking about irreversible, we weren't talking about this transaction in total. We were talking about the wire, and that once there's a wire of funds and the button is pushed to wire those funds, they can't get put back. That's what we were referring to.
Can we have Mr. Fauché address that issue?
The
I mean,
question.
the factual question, can a wire be undone? Not from you, the attorney, from Mr. Fauché. I mean, is there any problem with Mr. Fauché answering questions about his own affidavit?
No, there are no questions about that. So we can have that part
Right,
addressed.
Technically, we're not yet at the oral argument part of this, okay? And are you intending to put Mr. Fauché on the witness stand?
Yes, Mr.
Right.
Fauché, but again, what we had hoped we would do to proceed efficiently, have Mr. Fauché and others address the questions, but if the commission wants to break it down question by question, I guess we can deal with it that way, and Mr. Fauché can talk about his affidavit and the irreversibility of a wire transfer.
So that would be helpful, and then there will be oral argument after this where you can argue from the legal perspective what things mean, but we need a factual basis from Mr. Fauché, or at least I'm speaking for myself, maybe not for the whole commission, but I do have some questions for Mr. Fauché based on his affidavit and.
We can proceed that way.
Answers to our questions that we sent.
Yeah, if we want to proceed with Mr. Fauché, we can do that.
Why don't we do that? And it's your decision as to whether or not you want to have the lawyers testify. We're not
Understood.
ordering you to make them testify. We didn't expect they would necessarily be here, so.
I'd like to start with Mr. Fauché and see if we can address the concerns and questions from the commission to that witness, and then we'll take it step by step.
Okay.
Good morning, Mr. Fauché. Do you swear or affirm under penalty of perjury that the testimony you are about to give will be
like us to frame the direct, or would you like to ask your question?
If you want to have direct, that's fine. If you want us to ask, we'll ask.
We have sent out the questions, so I think Mr. O'Shea is probably ready for those.
Okay, so we'll just start with the commission's questions, and we can reserve for a later time this morning to discuss the burden of proof under the motion. But I guess turning to so let's just to get directly to the question that the commission appears to be interested in this morning. Are you familiar with the letter and affidavit in motion that was filed yesterday on behalf of Noverco?
Yes, I am.
And are you familiar to a statement to the effect that at a certain point in time, once Noverco makes a decision to proceed with closing on the transaction, it is characterized as, quote, irreversible?
Yes, I am.
And with respect to the reference to that action being irreversible, can you explain a little bit about the financial process that you were referring, that Noverco is referring to, and why it cannot, in your view, be taken back once that decision is made?
Yes, this is a very complex transaction dealing with a public, a public utility, a public company. And as the plan of arrangement states, everything has been agreed with the public company and the board of the public company through the plan of arrangement.
I'm sorry, it's really hard to hear you. If you could
Sorry.
speak up.
And I'm wondering if we
You'll
could
have
close
to
the
speak
door.
very close.
Thank you.
Is that better?
Yes.
So, the plan of arrangement states that after having all the approvals and approvals which were obtained through the shareholder vote, the Quebec Court of approval of the plan of arrangement, the FERC decision, and your decision last Friday, we have a certain time to close. So we started the process following that to call upon the equity from the shareholders, call upon the financing from the debt, and we've received all that money. What we meant by irreversible is it's at one point we will have to press the button and send the money to the transfer agent, which is AST, which will provide the money after that to the shareholders in exchange for their shares. So that's what we meant in terms of irreversible. Once we press the button, it's difficult to, once the money has been transferred into the account of the transfer agent, and the transfer agent does its work and sends the money to the shareholder to get back the money from the shareholder. That's what we meant by irreversible.
I have a follow-up question, so it's based on this.
Okay.
You indicate in your affidavit that has to be 5 days after, let me get your affidavit.
Okay, paragraph 7.
Paragraph 7. Are required to close within 5 business days of the fulfillment of all closing conditions, including regulatory approval. We did get the plan of arrangement last night, appreciate that. I can't find that, the plan of agreement. I cannot find that reference to the 5 days.
Can I approach him and give him the contract?
Please do.
Do you want to put that into evidence, by the way? Do you want to make this an exhibit? If we're going to talk about it, it's a complex document, maybe you ought to have it in evidence.
And if I might, it's obvious here that the copy given to the witnesses is marked up. It's not.
I can give him an
I
unmarked
have a
version
clean
if you
one,
want.
do you wanna,
Yes,
and
'cause
there's no, it's a
much as
copy.
I'd like to examine Mr. McLean, I don't think that's where we want to go on this.
We can do that later. Could you turn to, can I just help move things
If
along
it's
by?
part of your direct, that's fine, I can't
okay.
find this reference.
Can you turn to page, mark 17 at the top of the page? Are you on page 17?
Yes.
And so could you just read for us section 2.8, subsection 2, beginning the corporation shall file?
Yes. The corporation shall file the article of arrangement with the director as soon as reasonable practicable, and in any event within 5 business days after the satisfaction or where not prohibited, the waiver of the applicable party or parties in whose favor the condition is of the conditions set out in Article 6, including condition that, by their term, cannot be satisfied until the effective date, but subject to the satisfaction or were not prohibited, the waiver by the applicable party or parties in whose favor the condition is of those conditions as of the effective date and of the parentheses, unless another time or date is agreed to by in writing by the parties.
Can I interrupt? Could we move this into, I'm not going to object, I think it should be an exhibit of evidence, and I don't think that's happened yet. So could we just?
We have no objection to the admission of this document into evidence. It's a public document. It's been filed with SADAR.com since it was entered into in March of this year. It's been the subject of the Commission's approval. It's clearly relevant to the matter at hand. We have absolutely no objection to the admission.
Why don't we make it interveners cross exhibit?
If we're going to label it, I think we should label it the Commission's exhibit, since it is requested by the Commission.
We will admit it as evidence as Commission Exhibit 1. And that's the unofficial translation of Noverco Inc. and Noverco Acquisition Inc. and Valinair Inc. Arrangement Agreement, March 27th, 2019.
And if we might just follow up on a couple of questions with respect to the same area that Commissioner Hoffman has asked. Is it your understanding that that 5-day period was triggered when Noverco received all of its regulatory approval?
Yes, that is my understanding.
And when was that?
Last Friday.
What is your understanding of Noverco's ability under the obligations that it has with Valinair to postpone that date?
Excuse me 1 second. Because of the concerns expressed by Attorney Buffard, I want to make clear that if this gentleman's understanding is based on what the lawyers told him, that will be a waiver of the privilege. He's not a lawyer.
No, I mean, we can do this all morning,
If
but
I could finish,
if there's an
Mr.
objection to the question, then you can object to the
If I
question.
could finish, please. And therefore, if this question is answered, I intend to ask the witness, what is the basis of your understanding? If the witness answers, it's my conversations with counsel, the privilege will be waived.
I mean, we can try to answer the questions this morning, or if these are all legal questions, we can just make argument. We're trying to help the Commission and honestly the interveners whose motion has been filed, who bear the burden of demonstrating they meet the factors, and we're happy to proceed, but we're not under the threat that everything we say is a waiver globally of the privilege.
Call you as an expert in the community law.
Mr. McLean, I think we can foreshorten this if you would direct this for,
Okay.
Mr. Dumont, if you continue with this tactic of yours, the stay is not going to be granted because this event is going to continue until this transaction is done. I caution you that this kind of legal maneuvering, while it may be technically interesting for you to pursue, is not advancing the case. We're going to limit this witness's testimony to identifying in a document where the relevant information is. We're then going to have legal argument among lawyers during the legal argument portion of this as to what that means. No one's going to waive any privilege when a lawyer explains, particularly the lawyers for the client, what a particular provision of a document means. Are you clear about that?
I apologize if I offended the commission. I have a duty to my clients. My duty to my clients is not to waive legal issues. If I remain silent, I waive legal issues.
I'm not asking you to waive any legal issue. I'm telling you that we're going to limit this witness's testimony to a fact statement. He's not going to give us an interpretation of what he thinks this document means. And when we get to the question of what this document means, we're going to have legal argument. And no one's going to be waiving anything when we have legal argument.
That's very helpful. Thank you.
Thank you. So if it would be helpful, we can identify these provisions with this witness as referenced and leave the oral argument on the meaning of these provisions and the import of them to lawyers that can construe them. Also, Mr. Fauché is here to talk about the substantial harm of a stay and what that would mean for Noverco, Valinair, and the rest of its shareholders and the impact of disrupting this deal that's been carefully planned and choreographed for the last 8 months. And so we should, I think, while we have him on the stand, if it's okay, ask him direct questions about that.
That's fine.
So on page 17, we have identified the provision that Mr. Renaud Fauché just testified to under section 2.8 subsection 2. I'd like Mr. Fauché, could you turn to page 7 of the contract and identify for us the provision of the contract that is governing when this transaction must close by virtue of the agreement between Valinair and Noverco.
There's page 7 refers to, if you look in the definitions of page 7, refers to the outside risk, which means September 27, 2019, or such other dates that may be agreed in writing by the parties, provided that the effective date has not occurred by September 27. So, if you take into account that all the approvals have been obtained last week, and the court in Quebec, the shareholder vote, the court approved, the deferred,
Can you
and
move closer
everything.
to the microphone?
Sorry.
Just tilt it down. You can pull it down further if you like.
No, sorry about that. So the effective date has happened, and because of that, you have 5 days to comply with the agreement, which has been carefully negotiated through since the beginning of the year, and even and started even before and approved by the board of Valinair, and complied by that.
I think, can we just point out a couple other provisions and then move to what the stay would would do. So if you could turn to page 37. And could you identify, I don't know what the most efficient way of saying this is. We can present oral argument on this later, but can you identify the section of the contract that enables Valinair to terminate the transaction in the event that the effective time does not occur on prior to the outside date? Please refer to section 7.2, subsection 1, B3, and I guess is that the provision that terminates Valinair's?
Mr. McLean,
Yeah.
right.
I mean, this is,
Normally, we allow a certain amount of leading, but
yeah.
this is.
I mean, I think that this is more efficient.
If you want his testimony, just ask him the question, which provision of this?
It's a legal question. I think that we'd like to just, we can reserve for oral argument what provisions of this contract govern. I just think it's just not that helpful here.
That's okay.
Unless there are some specific provisions that you'd like to identify while we have Mr. Fauché on the stand.
I do have one that I wanted to ask. It's from your affidavit, Mr. Fauché.
Sure.
You say Valinair announced publicly that the closing will occur by September 27, 2019. And Valinair's shares have been trading on the expectation that the transaction will close on September 27th without payment of the common share dividend to public shareholders. Was that required by the,
Plan of arrangement?
agreement arrangement, and if so, what provision?
That was required, and I think it goes back to the previous, page 2.
Did the parties, when they entered the contract, expect the dividend to be paid after September 27th?
The dividend, for me, is not, September 27 was 5 days after, 5 businesses after, so the dividend is scheduled, there's a dividend which is scheduled on a regular basis to be paid to shareholders, and it falls after the 27th.
That is, is the outside date in the contract before or after the payment of the dividend?
The outside date in the contract is before.
And when the parties decided on an outside date, did the parties decide on when the outside date, when did the parties decide when the outside date would be?
I have to object to the form of that. I don't know what an answer to that means.
When did the parties decide when the outside date would be?
That was decided when the plan of arrangement was agreed by the parties. So it was decided irrespective of dividend or not dividend. The main idea for the outside date is to give enough time for any process in terms of obtaining all the regulatory approval which are supposed to be obtained for this deal to move forward.
Can you give us an idea how many shares are there of Valinair? Roughly, not exactly.
I don't have the full details of the shares, but there's a large numbers of shares.
You said like millions of shares or like thousands of shares?
Are the number of shares identified in the contract?
It's probably identified in the contracts,
In the circular?
in the circular.
Where's that?
But it's a substantial large number of shares because they're trading at they were trading at $26, and it's roughly 1 billion. So divide 1 billion by 26, we'll have the number of shares. I didn't make the calculation. That's roughly the number of shares.
Okay, all right.
I have a question. We've been talking about the outside date of defined as September 27. Later on in that paragraph, in that definition paragraph on page 7, there is a provision that the purchaser may elect prior to September 27 to extend the outside date by a specified period of not more than 6 months. If that is an option, then how is this point in time irreversible?
There's two things here, and I think the agreement provides for my recollection, and it always takes me a while to go back to exactly the same clause, that we can extend if we don't have the regulatory approvals. Here, my understanding is that we did get all the regulatory approvals.
So if we would have ruled on Wednesday, yesterday, instead of last Friday, you could have extended this contract by this outside date by 6 months, but because of the timing, you could not? And I can ask that
I'd
in oral
like-
argument.
Yeah, I think it would be just more helpful if we addressed legal questions through oral argument.
I'd be happy to do that.
Thank you.
You'll be getting that question. I think we should go to harm. He's never.
Yes,
done
yes,
that.
thank you. Setting aside whether it's substantial or irreparable, which I think is a question we can address in oral argument, can you help us understand what harm would accrue to Noverco at this point in time if a stay was ordered by the commission before the transaction was closed?
Yes. We've been planning, this is a quite a substantial, complex transaction involving publicly traded company. The process of getting the plan of arrangement with the publicly traded company, we had lawyers on both sides. I don't recall, but my recollection is maybe that 20 lawyers from Valina and others define exactly what would be the process, because it's a publicly traded company. It has to offer to the shareholder certainty. So with that, we have to go through the process of defining exactly what needs to be achieved to have certainty for the shareholders to receive what the plan of arrangement mentions. For example, Valina had to go through their own evaluation of our proposal, decide, hire people, hire lawyers, and so on, hire financials to do the proper evaluation, and so on. So the parties, we've started that, and it's certainty, creating certainty for the Valina. That's what, with a date and with all the conditions, that's what's got us to where we are right now. So in terms of the harm to Noverco, we've made a capital call to the shareholders. We've drawn down to ask the bank the financing for that. That has all come, and the harm, as I mentioned in my affidavit, there's a harm because we have the funding for the transaction is there. It's 1.2 billion. It's there, and so there's interest costs associated with that. We're giving you an estimation of more than $100,000. But also you have to take into account all the effort that has been put into that transaction, all the effort with our lawyers and all the partners. And I'll spend a bit of time there, because since it's a complex transaction, we had to talk to our different shareholders, the shareholders of HENCAP, the different funds which are there, explain the transaction, get their commitment. We also had to talk with our bankers, find the banking syndicate. So if we had to stay, we would have to undo everything which is there. Okay? There's a reputation issue associated with that, a long-term reputation issue associated with that. Difficult to quantify, I agree with you. Okay? But we tend to make sure that when we move forward, it's a very clear plan. The lenders have lent us money because there was a clear plan of arrangement in front of us. So there will be some reputational harm associated with that. Dividends, we expected to close having had all the approvals by the 27th. So we're foregoing future dividends that we were expecting to receive. We also have, and that's to the tune of 11 million, every quarter more or less.
Can you repeat that? I'm sorry. How much
11 million. We also have to pay, there's some preferred shares. We will have to pay extra for the interest of those preferred shares. We don't, not to pass on the assignments, but making sure this complex transaction, we undo this complex transaction and do everything. Undo the credit facility, undo the equity injections, all the conditions precedents which are clearly indicated in the plan of arrangement. Everything has to be undone. So those are what I would call very short-term harm to Noverco. There's also the long-term, but we can address that also if you want.
Does the issuance of a stay threaten the success of the transaction in your opinion?
The issuance of a stay right now, today, threatens the transaction because it's has been carefully planned in terms of the plan of arrangement which has been agreed by the parties. The state creates uncertainties on the other side of Valenay. When will that be solved? What are the next steps? What are the options? Shareholders of Valenay want certainty, and by bringing a stay or an appeal for a long term, that will create issues for the owners. That's for sure. So it does create some uncertainty as to what will be the result.
Can I just ask a couple clarification questions about what is said already, or I can wait until afterwards?
Well, we haven't had any even cross yet, so.
Yes, I think I'll just wait a little while and we can maybe make some clarifications.
All right.
I have just a couple of things
It's
kind of building off of what I just heard.
All right, sure.
I heard you discuss reputation issues.
Use
That's-
your microphone. Gotta use the mic. If the mic's not right next to you, it's not heard. Pull it forward. So
Can you hear me right now?
Yes, yeah.
Can you hear me in the back?
Yes.
Thank you. Mr. Fauché, I heard you discuss reputational issues if a stay were implemented here. To the best of your knowledge, is this transaction being reviewed or tracked by credit ratings agencies?
To the best of my knowledge, I would say so.
If a stay is implemented by the commission, would it affect would it have the potential to affect Noverco's credit ratings?
It would have a potential impact to credit ratings of Noverco and maybe more energy in general, because we don't know what's gonna happen in terms of the shareholders of energy.
And could that flow down to the Vermont utilities, Green Mountain Power, and Vermont Gas System?
It could. I'm gonna be real transparent here. I'm not an expert in credit rating.
But is there a risk that the Vermont utilities could have more challenges raising capital on favorable terms if this stays implemented?
I think it could.
Thank you.
Mr. Dumont?
Mr. Cochet, I'd like to start with one of your most recent answers and then work back. You mentioned an $11 million figure.
Yeah.
And perhaps because of the acoustics in the room, I couldn't hear your complete answer. What does the 11 million pertain to?
11 million pertains to the dividend that we're expecting to get once we have the shares, once we buy the shares, once the transaction is done.
Who pays the 11 million?
The 11 million is paid by the Valinaire to the new owners of Valinaire.
So the Valinier that's not a party to this case would have to pay the 11 million?
Yes, like normally it would have to pay to its shareholders.
So-
11 million.
Valinier's payment of $11 million would not harm Noverco, would it?
It would in one sense, Monsieur Dumont, because when we made the calculation and when we went into that deal, we expected, and Valinaire shareholders expected the deal to be closed at a certain date. So going forward, the dividend received or dividend given by Valinaire to its shareholder would come to the new owners, if you want. Now, when that's
I want to make sure I understand your last answer. You are explaining that if Valinier, that's not a party to this case, has not entered an appearance, has not hired a lawyer to appear even at the state proceeding,
You got that. Get to the question.
that if they paid the $11 million, that would be harm to Noverco. That's what you're saying, right?
what I'm saying is, when you do your calculation, okay, at some point you're a shareholder, right? If you're a shareholder, you expect what was from that time on the DCF, on the cash flow, that money that was sent to the shareholder, the new shareholder will have that money. Doesn't matter if it's Valinaire or somebody else, it's pure, you're now the shareholder, you expect the dividends to come to the new shareholder, that's all. And it's true for any companies in this.
Let me see if I can.
Sorry for my language.
No, that's okay. What you're saying is that there's going to be a shareholder dividend of $11 million under the arrangement that is set up here. That's to be paid on October the 15th. You're saying if the stay is granted, that $11 million will be given to Valinier's current shareholders.
Exactly.
And if the stay is not granted, that $11 million will be given to Noverco.
So,
Is that correct?
that's correct.
Okay.
Thank you very much for clarifying sometimes I get bogged down.
It's all right.
But when we do the evaluation of what price we have to pay, okay, we do a model and we look at all the cash flows that after the transaction are going to go back to Noverco. And that would be part of the cash flow that would go back to Noverco. So if the stay is there, we're not going to receive that. Somebody else will receive that. The actual shareholders will receive that. Like Chairman pointed it out.
trying to read the arrangement agreement in detail yesterday, you are more familiar with it than I am. Is there anywhere in the arrangement agreement that sets forth the expectation you've just articulated in response to the chairman's question? Where in this agreement is there any right or interest set forth to that $11 million?
I would
think
object,
that-
I just object to the witness being asked a legal question. I think that we have an opportunity to construe the contract. We've gone through this a little bit, but this witness is not a lawyer, and you know, he is, I think, capable of testifying about the business implications of this, the harm to Noverco and the case's ability to proceed through with these complex transactions in an orderly manner. But asking legal questions about what the contract means, I don't think is a helpful use of our time, and I think I'd like to object to it.
I think the question was, if I'm wrong, please, where is it? Just point to where it is. I don't think it was an interpretation.
I mean,
am I wrong?
That's correct.
I mean, it might, I might, I mean, if he knows where it is, if it's in there, that's fine, but, where it is and what it means, are the same thing. So, if it means that it entitles someone to $11 million or doesn't, that's a legal interpretation of the contract, and I think that there are others, counsel namely, that can argue or identify the legal requirements of the contract.
I'm sorry, but it seems like we're wasting a lot of time on this. Mr. Dumont, let me see if I can make it clear. If you're a shareholder, you get dividends. If you're not a shareholder, you don't get dividends. There's nothing in this document that says anything other than the fact that a dividend will be paid to whoever's shareholders as of September 30th. This document says that.
Well, if I may.
All the rest of it is just how stocks and bonds are handled. So if Noverco's not a shareholder on September 30th, they're not gonna get this $11 million dividend. If they are, they will. And I've read this document, there's nothing in here that says anything about, it doesn't say $11 million, but it does say that the shareholders as of September 30th will be entitled to the dividend. That's what this document says.
I'm asking the witness to point us to that paragraph. This is exactly what Mr. McLean went through in his direct examination, correct?
Can I get a computer?
If you don't know, you just say you don't know.
No, it's not that I don't know. Listen, I looked at it a while ago, and I didn't look at it recently, so,
Well, then I will move on.
Thank you.
I'll move on to the next question. Are you ready? Yes, you addressed reputational harm.
yes.
I want to ask you about the reputational harm question. Do you think that the harm that you addressed was caused by the decision to initiate the 5-day process within hours of receiving the commission's decision, knowing that my clients have hotly contested this? Is that in fact the cause of the reputational harm?
I'd object to the form of that question.
But
Overruled. You can answer.
the reputational harm is to undo the transaction right now. Okay? We've had a long process of setting up carefully the plan of arrangement with the assistance of our lawyers. Having to undo that while everything has been approved by the Board of Veterinary, approved by a court in Quebec, got the approvals from FERC. We receive the approval from this commission, who has done extensive review of everything through the summer, everything through, as per the hearing schedule and everything. The reputational harm is to say, okay, now we have to undo what is that. And I'll give you, for example, the financing, we'll have to go back and express to our syndicate saying, we didn't get it, we need to undo that. And next time we have to do a transaction, well, okay, there's gonna be some issues there.
Let me try and move this along. If you could look at page 7 of the exhibit, the definition of outside date. Does it state outside date means September 27, 2019, or such later date as may be agreed to in writing by the parties? Did I read that correctly?
Yes, but I think you have to go inside the document and what can trigger the agreement between the parties to extend that. And the agreement.
Go ahead.
And my understanding, again, is that once you have all the decision and all the effective decision, there's nothing that can, we would have to enter a negotiation. I don't know if the Board of Balanais would want to start again.
Let me follow this through. So you've agreed that outside, the definition of outside date includes such later date as may be agreed to in writing by the parties. Let's turn to page 17, which you read from before, section 2.82, which governs the 5 days to file with the director. That date in section 2.82 also says that date can be set as a later date if agreed to in writing by the parties, just as page 7 says, correct?
My understanding is that, yes, it could if the permits were not received or the authorization were not received by the effective date.
2.82 says, the corporation shall do X, Y, and Z, and at the end of the paragraph it says, comma, unless another time or date is agreed to in writing by the parties, correct?
But it has to be agreed by the parties.
So tell us, what effort did you make to seek that agreement?
If he wants to ask the witness questions about where things are located in the contract, I think that's fine. We did it on the, but
That's not the question he's asking now. You just asked him to discuss.
I'm going to object. I'd like to object.
Talk to Valenier about changing the date.
I'd object. He's jumping around on different. I think it's confusing for the witness. We're jumping around to different provisions. If the contract says if things can be changed by agreement, we can stipulate to that. But these provisions don't all apply in the same way. I don't think this witness is competent to testify as to the legal effect of these different provisions, when they can be triggered and when they're not.
And if the question that we're pending was that, we might entertain an objection. The question was, has he negotiated or attempted to talk to Valenier about changing the effective date?
No, I have no objection to that question.
Okay,
Sorry.
that's the question that's on the table, correct, Mr. Dumas?
Yes.
Okay. So, Mr. Fauché.
I'm a bit puzzled by the question because the plan of arrangement is, my understanding, is very clear that once we get all the effective, once we have all the authorization from all the different bodies which have been clearly indicated in the plan of arrangement, we can move forward.
Mr. Fauché, the only question Mr. Dumont has asked you is, have you talked to the other party to the transaction, Valenier, and asked them, would you be willing to change the effective date in light of the fact that the opponents of this transaction, or for whatever other reason, have sought a stay?
The plan of arrangement provides for, and I'm going to answer your question. The plan of arrangement provides for moving forwards once we receive all the approval receive all the different approval. So a stay or an appeal is a possibility in the future, can be debated in the future. And it can always be debated. Because we have all the effectiveness of, because we have all the authorization moving forward, we went and proceeded, and Valinet issued the press release on Monday saying they're gonna close on that. Did we have discussions? My understanding is they're fully aware of the state, and they're aware of the situation. But the plan of arrangements provides that once you have all the approval, you move forward. And we have to abide by what's written under the plan of arrangement.
I understand that. Is the answer to the question, did you talk to Valenier about changing the effective date subsequent to the date that we issued our approval order and this stay request was filed? If I understand what you're saying, is the answer is no.
The answer is no.
I think that's the question Mr. Dumont was.
Thank you.
He wanted to know the answer to that question.
Yes. Sticking with section 2.8 sub 2 on page 17. In answer to Commissioner Hoffman's question about the 5 business days to close, you referred her to that section. You read that section into the record. I want to ask you about it now. First of all, do you agree with me? It didn't that it pertains to filing the articles of arrangement with a director. It does not refer to closing.
Closing for me is a word that encompasses all the different action that needs to be taken.
So let me interrupt. I'm going to interrupt because that's important. So in answer to all the Commission's questions, when you've used the word closing, you did not mean when the lawyers sit down and the bankers sit down and the money changes hands. You were using the term broadly to include filing with the director. Is that what you mean?
It's all the necessary step that have to be taken.
So because maybe the language issues, I want to make sure, can you define in your own words what you mean by closing?
Closing is we need to wire the funds. In exchange for that, probably like any closing, midnight 001, the articles of arrangement will have to be exchanged.
So the Article 2.82 says the corporation shall file the articles of arrangement with the director as soon as reasonably practical, and in any event within 5 business days after satisfaction of the various conditions. It did not say on the same day as receipt of satisfaction, does it?
It says within 5 days.
So you could have waited 5 business days. You didn't have to do it the same day you received what you view as the approval, correct?
Again, I'd object to whether the question as to whether he had to, under the contract, wait. It's a legal question. We have people that can answer that question. This is not the witness for that question.
So in other words, that will be part of your oral argument?
We can articulate why, what is required by the argument in our oral argument, absolutely.
Okay. Mr. Dumont, are you satisfied with that? I understand that you could ask him what is his understanding, but at the end of the day, as you've already pointed out, he's not a lawyer, so his understanding won't change what this document means.
I hope the chairman won't accuse me of being obstructionist by the answer I'm about to give you, frankly. But I am not satisfied with the answer. If that is the answer, I have to move to strike most of his testimony, because most of his testimony until now has been his understanding of the contract. He can't go partway down the path, and when he runs into a question he's uncomfortable with, have his lawyer say, he shouldn't answer that because he's not a lawyer.
I don't have any problem with him answering what he thinks his understanding of the contract is, as long as you understand that what he's answering isn't a binding determination of what this contract means.
Well, of course.
Okay.
So I would like an answer.
Sorry, can we rephrase
Yeah.
the question?
You want to restate it? What? Or you want
I think it's best if the reporter reads it back.
Question, so you could have waited 5 business days. You didn't have to do it the same day you received what you view as the approval, correct?
I'm sorry, I'm gonna ask her to repeat, please.
Sure. Question, so you could have waited 5 business days. You didn't have to do it the same day you received what you view as the approval, correct?
There's 5 days in there.
Thank you. Paragraph 12 of your affidavit you've been asked about. This is where you state that you will incur interest over $100,000 during the stay. Can you explain what's the nature of the escrow account in which the funds have been placed?
What'd you say at the end?
What is the nature of the escrow account into which funds have been placed?
It's a typical account where you put the funds very short term, and since it's very short term, just before doing the transaction, before the funds are moving out.
So I'll ask you a slightly convoluted question. As lawyers, we have ethical rules that govern how we handle our clients' escrow funds. And the rule is that regardless of length of escrow, short or long, if there's potential to generate significant interest, we have a duty, a mandatory duty to put the funds into an interest-bearing escrow account. So let me ask you, could you have placed these funds into an interest-bearing escrow account?
These funds are not into escrow, they're in Noverco's right now account, okay?
So Noverco controls the funds itself.
Yes,
Is it holding the funds in an interest-bearing account?
I would have to check for that. Reason being, we didn't expect the funds to be there for a long period of time.
But that wasn't my question. Is the escrow fund accruing interest right now?
He said he'd have to check, he doesn't know, I don't know why we have to be so argumentative.
Can I ask a clarifying question? So who is charging that interest?
That interest, as I mentioned before, we've called upon both an equity capital call and a drawdown on the credit facility to be able to fund the transaction.
So it's the credit facility that's charging that.
So it's a credit facility that's charging that.
Could you change where that money is if the transaction is stayed?
Yes, it would change where that money is, but expense would be still greater than the interest on that. And I haven't had the particulars of looking exactly at the details of that.
So even if the money is not now in an interest-bearing account, if the transaction was, say, could be put into an interest-bearing account, or what you're saying is the interest that it would earn in that account is less than the interest that the credit institution is charging for that money.
I would expect so.
We do not know that, but we expect that.
I would have to verify.
And if the transaction goes through, the interest will still be due, correct, to the creditor?
Yes.
Right. So it's not a question that there's some special.
No.
This is the amount of interest. What the only thing that's different is that if this is stayed, that money won't be being used to buy the shares of Alinea. It'll just be sitting in an interest-bearing account, correct?
Correct.
I would like to ask you about the phrase you used. You referred to pressing the button. Once we press the button, certain things happen. You've indicated you don't know how many shareholders there are.
Well, it's take 1 billion divided by 26. I'll give you exactly more or less.
By 26,000. Well, why don't you do that so we have a clear record?
My phone isn't open. I'll have to wait. I didn't want to disrupt this commission,
Okay.
so I closed my phone, so sorry. I'll do
We
it.
have a calculator, right there.
Well, there's a good witness and he turned off his phone.
Yeah.
There you go.
Is it working? Don't give me one that's not working.
$46 million,
We have an answer.
What's the question?
46,153,846, and this is an approximation because I did 1.2 divided by 26.
So can you just state clearly now for the record, the number of shareholders?
Roughly in the 40, you have to be careful because there could be many shares with one shareholder.
Right, okay.
And that, and so in terms of shares, roughly 46 million.
Roughly 46 million,
Okay.
give or take a few million.
Give or take.
So you agree that once you press the button and those millions of shares are paid for by thousands and thousands, are paid for to thousands and thousands of shareholders, it will be impossible to unring the bell. That will be, in fact, irreversible.
That's what we meant.
Thank you.
Anything further? No. Mr. Direct?
Could I just, yes, please.
Okay.
If I could caution, I mean, we do have a double count deadline on making this decision. So if you could limit the nature of your.
Yeah, absolutely.
And I just want to follow up on Mr. Dumont, if I may. It's like trying to unscramble eggs which have been mixed together and getting back everything within the eggs. I'm trying to paraphrase that. So in terms of trying to get everything back, that doesn't prevent, from my point of view, other things to move forward.
If I may, I don't, that was the answer to my question, so if I may just ask him, what did you mean by it does not prevent other things going forward? What does that mean?
I just wanted to paraphrase the scrambling eggs here, that's all.
So after the 46 million shares are paid, what else could go forward that would protect my client's interests here?
I object to that question. That's a legal question. He can advise his clients on how to protect their interests.
Let me just get clear on one thing. If the stay is issued and you don't press the button, then you've testified there's some economic consequences, this $100,000, et cetera, the reputation questions and so forth. If we don't grant the stay, what makes the transaction irreversible is not those economic costs, it's the pressing of the button.
Correct.
So if you choose, because we still would have the possibility of reversing our decision on reconsideration, or the Supreme Court of Vermont were to reverse our decision, and you haven't pressed the button, then it will not have been irreversible. True. So that's really in your control, unless we grant a stay that keeps you from pressing the button, correct?
Correct.
Thank you.
Thank you. Could you just turn to, in the agreement, just for everyone's accuracy and clarification, could you, at a certain point, the contract starts to turn to D1, C1, et cetera, numbering on the bottom? Could you turn the page that's listed as D2 at the bottom? And under 6A, does that paragraph identify the number of common shares?
Yeah, it does.
And so does that,
So it's
does that more accurately reflect your prior testimony on the number of shares?
correct. So it's 10,000 preferred shares and 39,345, 102 common shares are issued and outstanding, and 4,000 Series A preferred
And what?
You have to speak up.
and 4,000
Could
Series
you
A.
start from the 10, you said
Yeah.
10,000, I think you meant
Capitalization,
10 million.
the authorized capital of the corporation consists of an unlimited number of common shares and 10,000 preferred shares.
I'm sorry, it looks like 10 million to me.
10 million, sorry, you're right. Sorry, I missed one. So 10 million preferred shares issuables in series. As of close of business on the date of this agreement, there was 39,345,192 common shares issued and 4 million Series A preferred shares issued.
Thank you.
Earlier you talked about the reputational harm in the event that Noverco is unable to finish what it started. And you described what is a clear plan. I guess I just want to ask, when you mean reputational harm, do you mean that your partners, financial partners, business partners, will have some trepidation as a result of Noverco's failure to follow through with this plan if it's unable?
Yes, everything is based on the plan of arrangement moving forward. And obtaining all the approvals was a condition to move forward. That has been announced on Monday, so not moving forward creates uncertainty for our lenders, creates uncertainty for our shareholders, creates uncertainty for everyone around this transaction. And as you know, uncertainty in the financial market is not really, you want to avoid uncertainty in the financial market. So to your question, that's the reputation means all that uncertainty, how we're going to deal with that uncertainty, what's going to be the impact. So that's the reputational harm I mean there.
That's all I have. I acknowledging that we're very limited on time. I do think, I don't know that we have the hour that we wanted, but we do have a significant number of issues that I think we could address in oral argument. So I'd like to do
you
that.
a question though,
Yeah.
because I see your letter and it says that noon on Thursday is when you want, that's an hour from now. We have an oral argument scheduled, and are you suggesting that we have to have a very short oral argument to meet that deadline? What is that deadline at noon?
In short, the parties are obligated, under the contract to close on this deal absent the commencement of what would be a significant renegotiation under the terms referenced by Mr. Dumont. Renegotiating the timing for this deal with the board of Valinair is not like me calling Mr. Dumont and seeing if we can get an extension on a filing deadline or stipulate to something simple procedurally. It's a pretty significant deal, and the contract requires the parties to close. And so in order for that to happen at that 5-day deadline, the 12 noon, as I understand it, is the time that we need to give the agent between now and Friday to make that happen.
Is that in the contract that you have 24 hours to renegotiate?
I think
I'm trying to decide
I'm gonna rely on co-counsel here from Montreal because they are far more familiar. Whether you mean the 12-hour period.
I just want to know, you telling us you need a decision by noon, it means we'll have to have a very short oral argument because we need time to deliberate as a board. What's more important, the noon or that we actually have oral argument?
In other words, what if we decided at 1 o'clock?
Yeah, no,
Yeah.
it's a good question. My name is Patrick Boucher. I'm a partner with McCarthy Tetro, and I'm making these legal oral arguments, and I'm not waiving any privilege by doing so, obviously. I'm here with my colleague Sonia Struthers to assist the commission, assist the parties in trying to understand a very complex arrangement agreement that I drafted, that I negotiated. That's what I do in life for the last 24 years for the benefit of Noverco.
I'm going to be rude and interrupt. He's not admitted, he's now providing facts.
I only want to know one thing.
Okay.
Is there something magic about noon today?
Yes, section 2.9 of the arrangement agreement on page 17 provides that Noverco shall, the last business day prior to the filing of the articles of arrangement that Mr. Dumont was mentioning, which are due by no later than tomorrow, so at the latest today, the money, 1.2 billion, that's not a small amount of money. It needs to be wired to the escrow agent. The noon deadline is to give enough time for the wire to go through a complex series of steps within banks and hit the agent's account before 4 p.m. because after 4 p.m. in Canada, wires can no longer be received. So in order to allow Noverco to comply with contractual obligations under the arrangement agreement, could we wait 12:15? There's a little leeway, but what's the ultimate? Generally, it's noon. So if the commission needs 30 minutes, I can make calls and try to arrange. So that's the noon deadline.
Excuse me, if I might, if you turn to page 17, payment of consideration, section 2.9, it says, it refers to the last business day prior to filing by the corporation of the articles of arrangement with the director.
Correct. The delay to file these is the last 5 business day, which is tomorrow, because all closing conditions have been satisfied. And unfortunately, and that's section 2.82 that you pointed out earlier, and the problem is that we're not dealing amongst ourselves here. We're not the only one at the table. We have a very major public company with a board of directors, which is Valinair. They have fiduciary duties, as you know, towards the company, their stakeholders. There's a lot of common shareholders involved. There's a lot of other stakeholders involved. We're forced to abide by the terms of a contract, unless obviously Valinair agrees to waive and renounce to certain of its rights. But Valinair is I've been on call. Valinair has been made aware of these proceedings. They've publish press releases confirming that notwithstanding all of that, they're expecting closing by tomorrow. The market is trading on the expectation that closing is tomorrow, that shareholders will not get the dividend, and you're going to create potential a market uncertainty by allowing to entertain any stay or delay in closing.
So we will have to make a decision by noon, is what you're saying?
Yes.
Mr. Chairman. Ms. Hawk. I would like at least
We're
9
gonna-
minutes
we're
for
gonna-
the presence.
I have a question.
I'm sorry, you're not a party to the proceeding and we're
Okay.
not allowing questions.
Okay.
We're on a tight time schedule, Mr. Clerk.
Okay, it was my understanding that the public could make comments, is that no longer?
No.
Not at this kind of proceeding.
Not
Oh.
at these hearings, our public hearings where the public can make comment. This is not one.
Or in PUC, you can make a comment as well.
Oh,
Dan?
I would just like at least 5 minutes to put a position in the record if possible.
Yes. All right, I think what we're gonna do is we're just gonna cut down this time for oral argument. We need time to deliberate. We're gonna do 30 minutes of oral argument. Which side of this is the department gonna be on?
We are recommending that the commission do not impose the stay.
All right, so Mr. McLean and Mr. Burke, you will have between you 30 minutes, 15 minutes, and Mr. Dumont, you will have 15 minutes. And you can start now. Do you want to reserve any rebuttal?
Yes, and I will not use 15 minutes.
Would you want to reserve any?
Yes, I will reserve 5 minutes.
Okay. You may start.
I have very little to add.
I'm sorry, would you like to start?
I have very little to add to what Mr. Gardner started us off with. He expressed eloquently what I was planning to say. The testimony we've had since then can be distilled down to this. Issuance of a stay would be inconvenient and uncomfortable for Noverco. Failure to issue a stay will cause irreparable harm to my clients. There's no way around it.
And is the substance of that irreparable harm that they will lose the effectiveness of the successful appeal? Is that the essence of the harm?
Effectiveness of successful post-judgment motions, and if necessary, after the ruling on the motions, effectiveness of an appeal, yes. There will be no remedy that the court could order that would protect my client's interest, and on remand to this commission, there would be nothing the commission could do.
This commission has already ruled last Friday that in our judgment, the record that we had in front of us did not provide evidence that there was a harm that would be associated with allowing this transaction to proceed. Why should we be concerned if an appeal is ultimately successful if we don't think that there's going to be any harm because we don't think the transaction itself creates any harm?
It's a great question, and I have two answers. The first is that whenever a stay pending appeal is sought, the lawyer in my shoes is always asking a court or a tribunal that has ruled against him to question the certainty of their judgment. That's the nature of the beast. And if we were to say, well, we've already ruled against you, so you have no likelihood of success on appeal, there would never be any stays pending appeal.
No, my question's a little different than that. The court might reverse us and say, you should have taken more evidence. Or you didn't allow this piece of evidence to come in the record. Or, in other words, on process. Not overturn our decision that on the record that was in front of us, there was no evidence of any harm if the transaction proceeded.
One can't separate the process from the result. If whenever the Supreme Court reverses and remands for failure to, for example, to make appropriate findings, the explicit purpose of the remand for findings and the explicit purpose of findings is to force the tribunal to sift or re-sift the evidence and potentially come up with a different decision. Only the most cynical of us would assume that you will not change your mind.
What evidence did you offer in the case that there would be harm if this transaction occurred?
What we offered was, I think, the irrefutable intent of the legislature, that it is not the absence of harm that is the legal standard. The legal standard the legislature explicitly imposes, there must be affirmative proof of positive benefit. And when we see in the ruling that there are critical matters as to which evidence is lacking, we think we have shown a likelihood of success on the merits. There are no findings that explain what the critical evidence is, and it's a betrayal of the burden of proof imposed by the legislature.
In our decision, what we ruled was that we believe that there was benefit to the transaction because of the increased ease of getting financing. My recollection is there's nothing in the record that came from you or your clients to indicate that that was incorrect. That assertion made by Mr. Fauché under oath was not true. Am I misremembering the record?
I would say not misremembering it, but taking it out of context, frankly.
We had nothing that said he was wrong about that, correct?
He was wrong, but in context. The context is, number one, that is one factor to be weighed in determining promoting the public good. If you hang your hat on the one factor and ignore all the others, you are not, in fact, performing your statutory job of determining the public good.
What were the other factors? What
All
were
the
the other
concerns
factors related to the harm that you asserted would be occurring if this transaction is approved?
all the factors laid out in the Haskins test, in which I can only assume are the critical factors that the decision refers to as to which evidence is missing. If they're not, if those aren't the critical factors, why are the factors critical?
Anything else?
The second answer to your question is, the question was, we've already decided this, why do you think an appeal would lead to a different outcome? Well, as I've stated, if the process that the Supreme Court precedents require were to be followed, unless one has completely become so cynical that the process doesn't count anymore, we have to assume that if the proper process were followed, the outcome could differ. And my second answer follows from the first. Look around this room. Why are these people here? We are in a time of great peril. They're here because they're worried. And they are relying on the process to protect their interests and the climate. If this commission exercises its discretion to say, our word is final, we are not willing to let our judgment be reviewed by the Supreme Court, it says a lot that you may not want to say.
I think we'll defer to Mr. Berg first. Does that make sense?
Yes, I think that's fine.
Okay.
Can you hear me?
Yes.
Yes.
Thank you. The department's been reviewing this transaction from the outset as to whether or not it benefits ratepayers. Our perspective in this proceeding, where the commission is generally is, do ratepayers benefit from these transactions? That's ultimately why we supported the transaction, and it's why we're imposing the position of a stay in this proceeding. As you heard Mr. Fauché testify earlier in my brief examination of him, there is a risk that credit ratings and the companies involved in this transaction could be damaged as a result of a stay. And as you are well aware, credit ratings are affected. That affects their ability to generate capital. In this case, it would affect their ability to raise both equity and debt capital. And to the extent those costs go up, those flow directly through to rates. And that's directly contrary to the finding we made that this transaction will promote the public good in the sense that it will improve access to capital. For that reason, and for the general concern that could be perceived to the broader financial industry as a household regulatory policy, could affect our utilities, and that would affect our ratepayers, which is why the department does not recommend a stay. I'd also like to speak to the issue of whether or not there's any value to an appeal, and I would remind the commission that under Section 107, subsection C, you still have regulatory remedies, even if this case is reversed. Even if the Supreme Court tells you that you are wrong, not just on procedural, but on substantive issues, you can still go back, modify any existing certificates or orders authorizing either or both the companies to own or operate a utility business under the provisions of this title. You can take away the certificates of public good. So you are not without remedy. The money might not be able to get clawed back from the Valenir shareholders, but you would still have remedial actions that you could take against these companies if the Supreme Court sends it back.
All right, let me ask you this, Mr. Burke. Do you interpret that provision to mean that, let's assume that the stay is not granted. Transaction goes through just as Mr. Fauché has laid it out. Money is transferred to all the shareholders and there's no way to get it back. And ultimately, either we on reconsideration or the Supreme Court rules that we were wrong and that this transaction should not have been approved, and that the reason is the reason that Mr. Dumont and his clients have presented, namely that the ultimate person who is benefiting from this is the Enbridge, and that Enbridge is going to end up with more of a minority interest than it currently has, and that that can be used to the detriment of the interests of the state of Vermont. The Supreme Court makes that ruling and says you got to do something. Do you understand that provision to mean that we would be in a position to issue an order that would be binding on Noverco and ultimately on Enbridge that said you may technically own more of this company than you used to own, but we are restricting you to only having X number of directors, and you can't have more than that number of directors. Would we have the power, as you understand that provision, to do that?
I would need to think about that and respond in more detail. You certainly would have the power to craft conditions. You're treading into constitutional grounds at that point in time would be my concern, because you have the potential for takings at that point. That being said, the commission can affect the taking. It's just there would be a subsequent remedy that would go forward for that. I think, though, speaking to Enbridge, I think one of the fundamental concerns in your order was Mr. Fauché's testimony during the initial evidentiary hearing as to whether or not there would be 3 or 4 directors on Energier that would be appointed by the Enbridge subsidiaries. And our position in this case has been there's going to be 3. That's what he testified to. That's what we feel they should be held to. And if there's not 3, they need to provide you notice of that as soon as possible. That being said, under Section 107, whether or not there's 3 or 4 on a board of 9 members is not a dispositive factor, because there's not a change of controlling interest. You're still a minority owner. You're a minority owner today. They will continue to be a minority owner. If they ever want to have 5 out of 9 or some other position that gives them majority control over the board, then they necessarily would be back in front of you with a separate 107 petition, where they would be a party to this proceeding, and they would be subject to the benefits and burdens, including discovery, or being directly subject to any orders you would have in evidentiary matters on the going forward. So that's a risk that we don't perceive. We don't expect the Supreme Court could reverse you on that and otherwise upset your finding that this transaction is in the public good as a result of that. But I do think, to answer your question more directly, if they did send it back on those grounds, I think there would be the opportunity to develop an evidentiary record that would find conditions that would be sufficient to protect ratepayers and protect utilities as well going forward, as well as the interests that Mr. Dumont's client is in.
Thank you. Mr. Plain.
Ms. Bouffard's going to start first. Thank you.
Thank you, and thank you for your time and attention this morning. I want to start by making the point that I think is important to just set the process that in the discussion in the parameters around it, that the decision that was issued by the Commission on September 20th was effective when it was issued, and that we could take steps based on that is consistent with the Commission's precedent and decisions that even the potential for an appeal, even if a motion for reconsideration is pending, that doesn't alter the effectiveness of the Commission's decision, absent something in that decision saying otherwise. With regard to the motion for stay, it's our position that the interveners haven't even begun to meet their standard for the heavy burden they must show. We laid out in our opposition the 4 prongs that must be satisfied by the moving party to obtain a stay. We don't think they've begun to satisfy any of those requirements.
What do you
First-
have to say about Mr. Dumont's argument that those are not the provisions that we should be looking at, but that we should be looking at Vermont Rule of Civil Procedure 62, which appears to be separate from the standard 4-part test for the issuance of the stay? I haven't seen any response to that.
I think that the standard that we have laid out is the standard that's the commission has used. It's consistent with the standard, and it should be the standard that's applied here. It necessarily has to be a heavy burden to impose a stay, particularly in a complicated commercial transaction like this, that just can't be stalled because somebody files a motion for reconsideration or an appeal. We think that the standard we laid out is the correct standard, and that.
And what do you think Rule 62 is applied to? I mean, it's a rule, it's written there, it appears to apply to this situation, Mr. Dumont. The fact that we've never looked at it before may only be because Mr. Dumont has never raised it before. Maybe he wins so many he doesn't have to ask for stays.
Well, we think that this is the standard that, it's a standard, that the 4-pronged standard is a standard that the interveners have also noted in their motion for a stay, that the standard should apply here. And so we think that is the standard. They've said so and presented evidence today that we don't think meets that burden, but on the question of whether they have shown irreparable harm. And we don't think, as we laid out, that there's a strong likelihood of success on the merits. There's some assumption here that if there was an appeal, that there would be a complete reversal of the decision, and I don't think that's accurate. We've heard from the department that there are other remedies. You'll recall that the interveners themselves suggested in their filings before the decision that there were a number of conditions that could be available. So we don't think there's a likelihood of success on appeal for the reasons.
Ms. Hart, will you argue, and we've seen it argued now in another case, that if they do appeal, that their appeal is moot because it's impossible to undo the transaction?
I'm not in a position today to say at this point what we intend to argue moving forward if there is an appeal filed. But I think that there are, it's just speculative to guess at this point what the arguments would be, what the outcome would be, and there are a whole range. But as we noted in our opposition, we don't think there's a likelihood of success. We've heard a lot about the information, the sentences in page 12, and we believe that the other parts of the order addressed any concerns about deficiencies in the record. And ultimately, what we think is most important is the Commission's finding that there would be no impact on the Vermont operating utilities in terms of their business, in terms of their planning, and we think that that was a critical finding. We don't.
Ms. Bouffard, I want you to talk a little bit about the irreparable harm claim that Mr. Dumont is making. He's making a fairly straightforward claim. If the appeal is successful and the stay is not granted, the appeal will produce no viable benefit to his clients. Is he correct? Is it, I mean, you've already said that this is an irreversible transaction, so if we don't give a stay, it's done. For this time forward, until Noverco decides it wants to sell its Valinair shares, they will own all of Valinair. Is that an irreversible condition that means that there's a harm that is substantial to these interveners who argue that there should never be a transfer of those shares to Noverco?
I don't think that that legal argument is sufficient to meet the requirement of irreparable harm. If that was the case, it would gut the commission's precedent that says that a commission decision is effective upon issuance. It would mean that in every instance that in every situation where entities intend to proceed, that a party could come in and demand a stay by saying it would be complicated to undo this. So I think there are.
You've not said complicated to undo. That's not, as I understand your client's position, it is that this is irreversible. It's not complicated. And that's why I don't think you're, opening the door to every case being subject to an automatic stay is applicable. This case, it's irreversible. If we don't stay it, nothing can be done to stop it. Why isn't that irreparable harm?
If I might, this question of whether or not the mootness or potential mootness of an appeal is irreparable harm is one that was raised for the first time by Mr. Dumont last night. I think the quotation that he provided in his brief says an enormous amount. The majority of courts have said that the mootness of an appeal does not constitute irreparable harm. And so that's one starting point. Second, mootness is speculative here. The transaction needs to be done. We heard today that you can't unwire funds that have been funded, but that does not render a legal appeal moot necessarily. And so, as Mr. Burke has noted, whether or not there are remedies on appeal is something that depends on the arguments, depends on the remedy sought, depends on ultimately whether or not the court would determine that it was moot. And so the interveners in this case cannot just come in and say, oh, this is moot. That's a legal question. If they want to show irreparable harm, as a majority of courts have said, they need to show real harm to their actual interests. And without that, you fail to meet the second prong of this commission's consistently applied test for where a stay is.
But Mr. Dumont's argument is irreparable harm, the two steps. First is the harm that he and his clients have argued. We've rejected it, but he's argued it, is that with Enbridge having a larger ownership interest, it will tilt the energy in the state of Vermont towards natural gas, which is a carbon-producing product and therefore is bad for the state, contrary to state policy. That's his argument. He's saying my chance to keep that from happening is eliminated if the transaction is irreversible. So his argument is that two steps. And my question to you is, what's your answer to that argument?
The answer, what's that? Yeah, we have addressed this in the briefing, but the first thing that they need to demonstrate is a high likelihood of success on appeal. Your rejection of the harm they claimed is in my view, based on the fact that there is no factual or legal foundation for the allegation that the outcomes that they speculate about could come about here. This proceeding has involved a lot of public perception and argument about those things, but the fact remains that there's no facts or evidence or law that support the notion that the kind of harm that they allege is even possible, is even within the remote possibilities in this case. So likelihood of success on appeal, which is getting back to the standard that's applicable here, it is, in our view, very, very, very close to zero. And that is a far cry from the high burden that they're required to meet. I would like us, if we can, to hear from our colleagues at McCarthy-Chotro about some of the legal requirements of this transaction that I think put into context some of the erroneous claims that we are rushing or trying to avoid or deprive people of rights. This transaction has been entered into back in March. It's been the plan the whole time, and I think the McCarthy-Control people can speak very quickly to, you know, why this is a normal, consistent transaction with the contract, and I think that would be helpful if you have time. And
I think the problem is that they're not admitted, they haven't asked to be admitted, they're not subject to our rules of practice if they appear here as lawyers.
Okay.
So we're disinclined to allow them, because then we're in that area in which Mr. Dumont, I think, can legitimately say, well, now they're testifying, they're like witnesses, and if they're witnesses, he's entitled to cross-examine, and then we go down that rabbit hole.
Humbly, I'll try to go do it myself, if that's okay. The
Question though,
yeah.
about the October, you heard me start to ask Mr. Fauché. The September 27th date is in the agreement here.
Mhm.
Had he issued the order, it had, the closing has to occur 5 days, is what the affidavit says from Mr. Fauché.
Yeah.
So had we issued the order on Tuesday, would the parties use the provision, the outside date provision, to extend the transaction for 6 months?
So the contract provides that in the absence of the conditions precedent to closing on the outside date, that Noverco could elect, but only under the circumstance that they do not have all approvals. So let's be clear, this is not just a discretionary choice under the contract. It's triggered by a specific set of facts that do not exist here.
But if we
yeah.
were to grant the stay, that provision would allow a 6-month extension.
Because then you would have it approved.
I believe that may be the case, I think that may be correct, and that's what is provided in the contract. We think that the issuance of a stay is, as described today, a very, very dangerous path for this commission and for the parties that are involved in this case, and would result in not just significant financial harm to Noverco, but it would disrupt what has long been a very carefully planned, complex transaction, and it would be contrary to law in the absence of the movement demonstrating they meet their burden under this commission's well-trod precedent on when a stay is appropriate, and therefore we think it's inappropriate or inconsistent with the law to issue that stay. I would just like to address a couple other things about the contract that I think have been unclear.
I think
Could I? Yeah.
less than a minute, that's it.
Okay. The option to extend under the contract is a one-off. It is not, it is a safety valve, a safety net in the very outside chance that the parties fail to obtain, after diligent effort, the regulatory approvals that are appropriate, as this commission decided last week. It carries with it, I think, as our witness has testified, significant uncertainty and risk, and threatens overall, will threaten the transaction. I want to address one other thing. There's been some question about whether or not we were
Mr. McClady,
yeah.
it's your client who wants a noontime decision, so.
We actually, we inquired this morning as to whether noon, in response to your question, is it noon, 12:15? What is the impractical point beyond which they could pull back? And that would be 1 o'clock at the very latest. So that we can put things on pause until 1 o'clock.
It would have been nice.
We asked it the first time.
We just found that out.
We just made the call to ask.
We've just found that out. We're not with.
Mr. Dumont's 5 minutes.
Yeah, go ahead with your second. Mr. Dumont, we'll come back to you when we can have some
So in addition to being, required to proceed toward closing, I want to emphasize another point that Mr. Dumont raised about the contract, that you can just renegotiate at any time. This negotiation, I think, as the evidence has demonstrated during the course of this process, was a significant lift. Moving and changing a transaction like this is not a matter that can be done with a phone call or one discussion. It involves a significant number of interested parties and players. And so I would just urge the commission to understand that the renegotiation of the outside date is a critical and fundamentally material change for the parties that are have agreed to this contract.
Right, but if I understand what you said in answer to the questions that Commissioner Hoffman answered, there is a one-off 6 month, there's no negotiation required associated with that. When we grant a stay, there's an automatic, under this provision, the effective is that you don't have the approval of the commission at that point, 6 months comes into effect. There's no negotiation, and I see counsel from Canada, if you consult with him.
Yeah, no, as I stated before, I think that's right. We are entitled, Noverco is entitled, in the absence of its regulatory approvals, to invoke that provision. I would just caution you that I think the evidence demonstrates that invoking that provision for Noverco doesn't come without risk, without a significant impact, and on how the shares are trading, on how the parties are treated financially. It has many, many impacts, and so the idea that we can just
understand that, but I just wanted to be clear. It's not that there's a negotiation associated with that one step. It's
no,
just
that is
there are
a unilateral right of Noverco's. It runs to their benefit.
Right.
And they bear the risk of proceeding with closing in the face of further litigation like the motion reconsider.
Mr. Dumont, we'll
Thank
give
you.
you 5 minutes
Thank
if
you.
you need it.
I'm going to first refer you and your counsel to a wonderful precedent that is directly on point and very useful. It's Judge Walsh's decision in the Environmental Division in Re Devonwood Investors, decided May 22nd, 2017. It's docket number 39-417, and he addressed this very question. A stay was sought and was denied, and this is the logic. Harm is irreparable if it would impair the court's ability to grant an effective remedy, citing Wright and Miller. We recently explained that allowing construction to move forward after a permit has been granted, but while that permit is being challenged in this court, will not lead to irreparable harm. This is because the court has the authority to impose penalties and order the removal of a structure built without final permit approval. The same principle is true regarding the deconstruction involved in this particular case, including seeking to remove an existing parking garage. Removal of the garage will not cause irreparable harm where the proposed project calls for building a new garage. The point is, there's no irreparable harm in that case because the structure could be removed if they don't get their permit. They're going forward while it's pending at their risk. And that does not apply here.
Let me ask you about
Yes.
that, because I asked this question of Mr. Burke, and to some extent, Mr. McLean alluded to it without making a specific commitment, which is understandable. Let's say that we don't grant the stay, sale goes through, Enbridge has its larger share, and your concern is not technically with what their share is, your concern is with whether or not they exercise that additional authority to get more control in the board of energy. So the Supreme Court agrees with you, and they say we were wrong, and they say there's real harm here, and that we should have imposed conditions, and we should have imposed a condition that prevented Enbridge from having more than 3 seats. Is there any reason why that isn't like tearing down the parking garage? Don't we have that out if those conditions exist and the Supreme Court so rules?
I asked myself that very question preparing for today, and the answer is no. It's no for three reasons. The first is that condition, the conditions we suggested, we asked them, only would apply, they're only feasible before the closing, because there would be very material adverse changes to the terms of planning the contract. So our goal was, if you're going to approve this, do it with the conditions that will protect somewhat the public. But if the closing happens, it's too late to impose the conditions because they would substantially impair the rights of the parties to the closing, and you won't be able to unring the bell. It would be, as Mr. Burke said, something like a taking, if it's feasible at all. It's hard to imagine how you could do that. But second, part of our concern was not the fourth C. It was going from 3/12 to 3/9. And that's going to happen condition or no condition if this closing goes forward.
And let me just understand, whether we dealt with the question of how many seats they have or how much quote power they have, ultimately we control what happens at GMP and GS. Given that, if Enbridge were to say, okay, we want to stop this introduction of electricity into areas where natural gas is currently going, and we want to increase the amount of natural gas that gets sold to Vermont. Okay, and I understand that's the concern, and that would be a concern to us too. We can stop that, can't we? We can tell VGS and GMP, we're not going to approve that plan in which GMP is ordered, apparently, to withdraw its effort to have cold weather heat pumps introduced into the territory where VGS is selling natural gas. We could just say, no, you're not approved to do that.
Well then, frankly, you need to reverse the order, denying our motion to join GMP and VGS as parties.
And we don't need to do that, do we? Because when GMP or VGS want to take any actions, they have to come to us.
No, they don't. The utilities are granted broad discretion in day-to-day management, and it's only when they need 248 approval that they come before you.
No, it's their IRPs that have to come before us, their rate plans that have to come before us, their multi-year rate plans that have to come before us. Trust me, Mr. Dumont, if we want to have them not do something or do something, we have the power to do that. Take it as a given. Given that we have the power to do that, won't we be able, if all of the events that you foresee happening were to happen, A, we get overturned by the Supreme Court or we reverse ourselves, or B, we don't get overturned in these concerns that you have with Enbridge using this increased authority to do things that are contrary to the public interest, why can't we just make sure that that doesn't happen?
Because as this commission and the court has said over and over again, you do not sit as the managers of corporations. That would be impermissible. You only review them when they require specific approvals. And it would be unlawful for you to assume the day-to-day management of GMP or VGS. But you have enough to do anyway.
This has nothing to do with the day-to-day. The day-to-day isn't what you or your clients are concerned about. You're concerned about programs. You're concerned about, VGS comes to us after this is done with Enbridge's encouragement, comes to us and says, we want to add another 500 miles of natural gas pipeline in the state of Vermont. They have to come to us to get approval for that.
No, they don't.
Why would not they have to come for
Because
248?
because it's an interstate, you have no jurisdiction.
That's not entirely true, Jim. Under 248, they do have to come. Even for jurisdictional pipelines, they have to file a petition.
Yeah, they have to file a petition. FERC makes the decision. You don't have any decision-making authority in an interstate gas pipeline, under the Natural Gas Act. But the point is that, yes, if certain things rise to a certain level and they come to your attention, you can impose penalties, you can do sanctions. But what this is about is tilting the balance, putting the thumb on the scale. As Mr. Fauché described, they have a series of interlocking directorates. They make decisions so informally that even $100 million decisions, it's basically a conversation, he said. There is no way for you to find out how that scale is the thumb is being placed on the scale.
All right. Okay, anything else, Mr. Dumont?
Yes, and it relates to the question you just asked. We don't really know the impact of this proposed transaction in your decision on the management of Energy or Inc. because you don't have the bylaws of Energy or Inc.
Sorry, that's not relevant to the stay, is
It is because it answers your question about what do we hope to gain by a Supreme Court reversal. If the Supreme Court were to say that the commission erred by ruling on the control of Noverco without looking at the bylaws that Mr. Fauche's testimony relied upon, and which the reply brief from Noverco relied upon, and which you've assumed you know the meaning of, there's no basis for much of the decision. And those bylaws are central to the question of control of Noverco, and we don't have them. And the bylaws are what will determine, for example, on certain decisions, and you can look this up in Canadian decisions saying in some corporate bylaws, you can only take certain steps with unanimous consent of the full board of directors. If the bylaws here require unanimous consent, then having 3 out of 9, as opposed to 3 out of 12, gives you a lot more power. And we just don't know until we see the bylaws. So I guess I'd like to wrap up by getting back to the point of what happened last Friday. Was it reasonable to immediately set these wheels in motion to try and moot out the post-judgment motions and the possibility of appeal? The Articles of Arrangement, as a condition precedent, required that there be no pending or threatened actions, legal actions. And threatened means to give signs of, warnings of, or to portend.
Can you cite us to the section of the?
Yes, it's in the brief we filed last night on page 6.
Okay. All right.
And so it seems very clear to us that the decision was made last Friday to set the wheels in motion to foreclose our appeal. Thank you.
Could I respond to the last point, please? Because it's important.
Yes. Go ahead.
This contract does require Noverco, or does permit Noverco under, it protects Noverco in the event that there's pending or threatened litigation. Its option under that provision is to not close. So be clear, they cannot extend for 6 months based on threatened litigation. They can decide not to proceed or renegotiate. And as we've heard today, the evidence presented by the witnesses, that's a significant undertaking, and who knows what the outcome of that would be. So I just want to be very clear, the reasonableness of proceeding in the 5 days is unconnected as a matter of law from this section. This section does not permit them to delay with all the regulatory approvals in process, in place. Unless the commission feels it's heard enough, I also think that the conversation that we've just had here demonstrates that we're not meeting the prong that's necessary for a stay here under the first prong, the likelihood of success. These issues that have been discussed are all okay.
I just want to make one point of clarification. Mr. Dumont picked up on.
Microphone, please.
Mr. Dumont picked up on a point that I made during the argument I made earlier about conditions, if there's agreement. And I just want to clarify, I was trying to answer your very specific, narrow question as to whether or not you could limit the amount of seats that one company could have on another company's board of directors. And I think that particular question might raise legal problems, but to a broader question as to whether or not there is a scope of conditions that could be imposed on the transaction to cure any deficiencies that have been identified, yes, I certainly think there's a much broader range of conditions that can be imposed on the proceeding, even if the transaction is.
All right, thank you. Thank you all
Thank
very
you.
much.
Thank you.
And to all of you in the audience, I hope most of this was understandable. We appreciate your attendance and your passion. And we will decide before 1 o'clock. It may not be written, but it will be clear.
Probably should close.
We'll come down. All right, so should we just say 1, or should we say?
Quarter to 1.
All right. So we'll come
We're gonna
back
announce
in
it
an
here.
hour.
Yes.
We're going to announce an oral decision at 12:45.
Okay, thank you.
Yeah. There'll be a written decision.
Oh, yeah. Let's do it.